For judgment, item numbers 1 and 2.
Yes, for the reasons assigned in the judgment, the writ petition is allowed. The impugned seniority list is hereby set aside, and the respondents are directed to redraw the seniority list within a period of 3 months from the date of receipt of a certified copy of this order. That is in respect of WPC 127 of 2019. Okay. And this is... Yes. Then in respect of the other writ petition, that is WPC number 95 of 2019, reliance has been placed upon the earlier decision. So this will cover, the case is covered by the judgment rendered in 127. 2 separate orders, but yes.
Your Honor,
Yes.
in respect of item number 13, is the leading counsel, Mr. Malhotra, is in the gospel camping for 3 days. May the matter be
Which
set
item?
after 13.
1-3.
Yes, 1-3 of part 1.
So when do you want it?
After 2 weeks.
Okay, straightforward boy. Straightforward on behalf of Mr. A.R. Malhotra, learned counsel for the petitioner who is said to be having some personal difficulty. Matter stands adjourned for 2 weeks. Yes.
And Your Honor, in respect of item number 11, may the matter be after
Similar
a week.
order. Have you informed the other side? No objection?
No objection, my lord.
Okay, as prayed for on behalf of Mr. A.R. Malhotra, learned counsel for the respondents and not objected to by the other side, the matter stands adjourned for 2 weeks.
Flash.
Obliged, my lord.
Yes, Mr. Lord.
Mr. Lordship, this, I want to make a mention, division bench tomorrow.
You'll have to mention it before the division bench.
Lordship, we have the motion stage, that's why.
No, you mention it tomorrow before the division bench, if it's a division bench matter.
If they are not listed, yes.
For motion, have you filed it?
I have filed yesterday.
You filed, okay, you filed it, you mentioned tomorrow, we'll consider.
For orders, item number 9.
Yes.
Yes, by this application, my lord, the applicant is praying for suspension of sentence and release on bail. This applicant had
Will issue notice at this stage? All right. Heard Mr. Lal Pianfel Atsong Thu, learned counsel for the applicant, who submits that by filing this application under section 430 of the BNSS 2023, the applicant prays for suspension of the sentence. Imposed upon the applicant via order dated 6/12/2024, pending disposal of the main appeal, and for releasing him on bail. Stop. Next para, issue notice, returnable by a week. Ms. Mary L. Kiante, learned additional public prosecutor, accepts notice on behalf of the state. As well as, what about the number 2?
Notice will have to go.
Number 2 is who? Who is number 2?
complainant, my lord.
Complainant.
Yes,
Complainant. So I think notice will have to go to him. It's a private person, isn't it?
yes, yes, my lord.
Okay, returnable by 2 weeks. So and so, learned counsel accepts notice on behalf of respondent number 1. Applicant to take steps for service of notice upon the respondent number 2 by registered post with ADD within 3 days. Yes, list the matter again after 2 weeks.
Obliged, my lord.
Then, 1 minute, what about the appeal?
My lord, the appeal was first filed in January and then it was moved and appeal is already admitted. LCR was called for.
LCR is arrived, my lord, then the,
LCR has come, so
Yes.
paper book should be prepared, isn't
Yes.
it?
Yes.
it is in the process of
Then
making,
in
my lord.
the, is it in the process? I don't think so. There's no order as such. Okay,
6-2.
okay. No order is required.
Item number 10.
Lordship, this IA is in respect of an application for substitution of the deceased respondents, respondent number 1, 3, and 5,
You're for the applicant
and for the applicant.
as well as the appellant.
Yes, Lordship.
Who has expired?
Respondent number 1, that is VL Huabzawa, and VL Huabzawa was the legal representative of respondent number 4 as well. So both these 1 and 4 will be represented by, as per page 5, by Srimati Varo Zingi, daughter of Walkuma, resident of Upper Republic, Aizawl. And respondent number 3 had also expired.
When?
Lordship, respondent number 3. On 4/11/2021.
Okay, then what about 1? When did he die? VL Huabzawa,
Well, who observed on 12/2/2019.
19.
2019. Lordship, during the course of proceeding of the trial court, no information was given by the plaintiffs as to whether they were still living or whether they had expired.
Who was
Only
the
when
plaintiff? Who was the plaintiff?
The plaintiff was, the plaintiffs were the respondents number 1 to 5.
125.
1 to 5.
1 to 5.
Yes.
And
1, 2, 3, 4, 5.
Civil suit, isn't it?
Yes, Your Lordship.
Civil suit was decreed in their favor.
It was decreed in their favor, and against that we have approached this honorable court.
When was it decreed?
(17/10/2024).
24. Number 1 expired in 2019,
Yes.
3 expired in 2021, judgment passed in 24.
As if, showing that they were still alive. No information whatsoever was given by the plaintiff's no information was given to the plaintiff counsel, and plaintiff counsel also did not inform the court. So we were in the presumption that they were still
Then
alive.
how was the evidence led then? Plaintiff did not examine himself? Yes, what do you say?
My lord, in this regards, in the trial court, there was different counsel. So in this regard, I have no knowledge regarding this matter.
Same old story, isn't it?
Yes, my lord.
I was not the counsel. Court also will say, I was not the court who was handling this matter. Nobody is responsible. See, basic thing is when you take up a brief, you take the brief as a whole. Not from this stage only I handle. You should go back in time and see what had happened so that you can relay back the information to the court,
Yes, my lord, I'll look into
isn't it?
Yes, my lord.
If you keep on saying that I was not there, I don't know who, it was somebody else, XYZ, that cannot be the ground. What about this application? Do you have any objection?
My lord, in the substitution, I have no objection, my lord.
You have no objection.
Yes, my lord.
In fact, it's as stated by the applicants in this application, at para 2, what we have stated is that on 4/3/2025, Sri Ricky J. Islalwatfela, learned counsel appearing for the respondents number 2 and 5, before this honorable court had verbally stated that respondents number 1, 3, and 4 had already expired during the proceeding of the connected civil suit number 40 of 2014. And in fact, he, on the basis of information furnished to us regarding as to who will represent those deceased respondents, we have been able to file this application for substitution of those deceased respondents.
What is the issue involved here?
The issue is regarding land. The
Dispute over land.
Dispute over land.
Okay. You were the defendant.
Yes, yes.
There are a number of persons here. Appellants are 4 in numbers.
Appellants
Defendants
four
are 5 in numbers.
Yes,
So it pertains to one parcel of land or different lands?
different lands on the Wellbank Road site.
All right, then we'll consider and pass necessary orders in this application. I heard Mr. Sheila Ramzao, learned senior counsel, assisted by Miss Emira El Mar, for the applicant, who submits that by filing this application under Order 22, Rule 4, Bracket 1, CPC, the applicants pray for substitution of respondent number 1 and respondent number 1, 3, and 4 by their legal representatives in view of the fact that respondent number 1 expired on 12/2/2019, while representing respondent number 4 as well. And the respondent number 3 expired on 4/11/2021. First of the Learned Counsel submits that the applicants were never informed at any point of time about the demise of the respondents concerned, and therefore, upon one more hurdle is there, Mr. Ramzawa.
Lordship.
What about limitation?
Limitation, that 90 days period, that is there.
No,
For
no,
substitution.
For substitution.
For substitution.
And that limitation run from which date?
It will have to run from
Let us see the provision.
the date of death or date of knowledge of the death.
Which is the article? For substitution.
(120). Schedule 120, Your Lordship.
No, where do you say that it's from the date of knowledge?
Your Lordship, here what is written is the date of death of the plaintiff, appellant, defendant, or respondent, as the case may be. There is no specific provision as to whether it should run from the date of death or from the date of knowledge of the death of the deceased. But here, the reason why you have filed this application is that even the court was under presumption that the respondents or the plaintiffs at the time of the proceeding of the civil suit was under consideration that they were still alive. No information whatsoever was given. And it has to, if this application cannot be accepted as it is, it has to be traced back to the trial, the proceeding of the civil suit. When that was not furnished to the court, the duty was there, on the counsels.
All right,
to
Mr.
inform.
Ramzawa, we'll do one thing. You explained that by way of an application. I don't think we can condone it just like that. You file an application for condonation of delay, giving the reasons that it was never brought to your knowledge, and decree judgment was passed on so and so, and presuming that the parties were still alive, you had proceeded to file until unless one fine day on this date you came to know that they had died.
Right.
So that's why I'm filing this application for delay of this much days. So we'll consider it.
Under para 2A, Your Lordship, under para 2A, though I have not filed a separate application. What I have stated,
Let there be a separate application, since you have just read the provision of Limitation Act.
yes,
So I think that'll be better to put things in order.
all right.
As prayed for by Mr. Sila Ramzawa, 2 weeks' time is granted to file appropriate application seeking condonation of delay for filing the instant application for in pleading the legal heirs of respondent numbers 1, 3 and 4.
God bless.
For admission, item number 3.
My lord, paper publication already done, my lord. I have to file affidavit, my lord. Only, so, paper publication already done, my lord. Only to file affidavit, my lord. So, today, during the course of the day, I am filing affidavit, my lord. And may I pray this matter may fix on 7, my lord. Today, I am going to file the affidavit as per court order, my lord.
You are supposed to serve to whom?
My lord, the private respondent here, my lord. In
All the respondents except 1 and 87.
yes, my lord. Already paper was done, my lord. It is done.
You have done newspaper publication?
Yes, my lord.
Okay, Mr. S.K. Mehdi, learned CGC submits that newspaper publication for service of notice upon the private respondents has been made by the petitioner in terms of the order dated 25/2/2025, and therefore he prays for 2 weeks' time to file the same by way of an affidavit. Praise aloud. As prayed for, is the matter on 7th of April,
Other service,
2025.
Item number 4.
4, 5, and 6 minutes. 25 to order.
All are 25/2, isn't it?
Yes, ma'am.
Okay. Similar order will go in item 3, 4, 5,
And 6.
6. All same.
Highly appreciated.
Item number 7.
My lord, in this matter, may I seek for another 2 weeks' time, only another 2 weeks' time, my lord, for filing of rejoinder affidavit.
As prayed for by Mr. Bila Ramenga, learned counsel for the petitioner. Further 2 weeks' time is granted for filing the joinder affidavit. List again after 2 weeks.
Item number 8.
My lord, in this matter, that's notice upon respondent number 2 has not been completed, but the same can be accepted by Mr. Samuel Patrick.
You can accept number 2. Who will accept?
2 and 3.
Who's 2 and 3?
Any Shahidis here? my lord?
And how many respondents are there? Otherwise?
6.
6.
Yes, my lord.
So, notice in respect of the others is complete.
It's complete, my lord. The others are represented.
One is by CGC.
Yes,
what?
my lord. One is by CGC.
And 2 and 6, Mr. Samuel.
Yes.
For Kala also, Mr. Samuel.
No,
No,
my
my
lord.
lord.
For Kalam is London Louis.
I'll be representing only 2 and 3, man.
Okay, 2 and 3. Stop office note dated 17/2/2025 and 24/3/2025 indicates that unserved notice has returned back from respondent number 2 and AD card has not returned back from respondent number 3 respectively. Stop at this stage, Mr. Samuel Vanalshi Sangte, learned counsel, submits that he has instructions to appear on behalf of respondent numbers 2 and 3. Stop. As such, notice upon respondent number 2 and 3 is complete. Are you to file a power or something? 2 and 3? You file your power?
Yes, ma'am.
Mr. Samuel Vanalshi Sangte shall file his power within a week's time from today, as prayed for. Then what else to be done?
Your Lordship, for respondent number 6, I have already filed my power, Your Lordship.
What about affidavit?
Your Lordship, I'm yet to receive the instructions, especially for respondent number 4 and 5 also, Your Lordship. So if 3 weeks' time may be granted.
Next para, as paid for by the learned counsels appearing for the respondents, 3 weeks' time is granted to obtain instructions and to file counter affidavit. List again after 3 weeks.
Much obliged, Your Lordship.
Obliged.
For hearing, item number 12.
Yes, Mr. Aldrin, after a long time.
Yes, my lord.
What is this matter?
This is an appeal under PC Act. Appeal against the order of 7/8/18.
Okay, who's for the other side?
Miss Mary.
Where is she? Mr. Samuel, Miss Mary is required. She's come?
She's here, my lord.
She's on the leg. I can pass on the information,
Okay.
my lord.
Ask her to come here once she's done.
Yes, my lord.
You may start.
Pardon, my lord?
You may start
Okay, my lord.
if you want to.
The appellant is convicted for 1 year and a fine of rupees 20,000.
Manghak, you may go.
My lord, may I take you to page number 1?
Page number 1.
This is the FIR.
Yes.
As various NGOs, we have performed careful scrutiny of the development fund sanctioned for our society during 2009-2012 from Zol Nuam, RD block, which was procured through RTI Act by MNF party and distributed in every household. Upon careful study, Kanmun VC has not yet performed any work in various areas, despite procuring the funds sanctioned for these causes. We therefore request you to investigate upon this matter and thereafter take the harsh legal action against the defaulter. I therefore requested you to take necessary action against the above mentioned issue. Enclose 1. Response to RTI issued by DPO MNERGS, Mamit District, Mamit. So, my lord, the thing is, Mamit District had sanctioned some amount of money to the BDO, and the BDO there again distributed money to the villages through VC. And there is a sanctioning of work, earmark work. So, upon the earmark work, they have sanctioned money by the district capital from Mamit, and then send it to the block. So now, what they have stated in the FIR is that the money which has to be utilized was asked to the RTI to the Mamit district, not from the BDO office. So Mamit is the project director office. So from the project director office, then they have given to the block. From the block, and they distributed to the several villages. So the BDO and BDO office is one of the main important witnesses. So all these witnesses from the BDO had deposed in my favor. So I'll come to the
The fund which was supposed to be spent, this was supposed to be spent on what? Development fund.
Development fund under MNREGS.
MNRGS.
They used to say NREX by the villagers. It's a National Rural Employment Guarantee Scheme.
Under this scheme, the development fund is there.
Yes, my lord.
Where to be utilized? Where?
to the villages. my
Which
lord.
village?
Kanmun village. I am the VCP.
You are the VCP.
Yes, my lord, Kanmun village. And the block is Zolnuam, RD block. Zolnuam, RD block.
Then this was for the year 2009, 2012.
2009, 2012.
Then who has sought for the RTI information?
It's a political case, my lord.
RTI by whom?
RTI by the various NGOs, they said. NGOs.
Applied to which office?
By the MNF party.
Huh.
They have applied by the MNF party
Okay, to which office?
to Mamit district, DPO,
DPO.
yes, district project officer.
Okay. So, information has been sought regarding the fund
Yes.
meant
the
for Kanmun
villages.
village
Yes,
from the
DPO,
DPO.
Mamit.
So, anything wrong in that?
Because, my lord, the BDO can divert that money.
Who?
BDO,
BDO.
yes. Diversion can be made under the scheme.
Okay, diversion is another thing. What I was asking you is, you were initially saying that although the matter pertains to this part of the district,
Village.
information was sought from somewhere else.
Yes. No,
So,
information has to be sought to the BDO.
to the BDO,
Yes.
not to the DPO.
No. BDO has utilized money to the villages, my lord. So many villages. So under Zone 1 RD block, there are
But-
around more than 20 villages, my lord.
But encloses the RTI issue by DPO.
Yes.
Yes.
So they get it from the DPO. Anyway, the
Information.
fund, yes, the fund is coming from the DPO, but the BDO has utilized it somewhere else. And the work has been done by the VCP under the guidance of the BDO. That
BDO.
is our case.
I see. Okay. Is that the evidence also?
Yes, my lord. Everything is in evidence, my lord.
Okay.
So the trial court did not trust the BDO office. That's why I was convicted, my lord.
Okay. This FIR is dated? What is the date of the FIR?
24/9/2015.
No, that's the exhibit.
Then, okay. Or date 9/4/2015. At the top, my lord.
The original copy is not there.
No.
But see, the judgment starts like this. A complaint dated 1/8/2012 was jointly submitted by the SP, ACB, and, okay, submitted to the SP, okay, ACB by so-and-so, so-and-so. So the date is different, 1/8/2012. From where do we get this date? Give me the case record, please.
A complaint dated 1/8/2012 was jointly submitted to the SP ACB by C. Vanalpek and 2 PC. I think it is 1/8/2012, my lord, the date of the FIR.
Yes, it's 1/8/2012.
Yes. So now, may I take you to page
Just a
2?
minute, okay? 1/8/2012. Unless we see the original copy, it cannot be ascertained what date is that. Because all these dates are basically the exhibits.
Yes, my lord.
On that date, this date.
Yes, my lord. And the copy of RTI is also not included in the charge sheet.
Yes, please proceed.
Page 2, chart.
Page 2. Yes.
At serial number 3, nature of offense, that you had in your capacity as a president of Village Council, Kanhun, Mami district had misappropriated funds under Zolnom RD block during the year 2009 to 2012 as follows. Rupees 2,26,395 sanctioned for construction of slab culvert at Goboye to Markai, West Right WRC Road, Kanhun. Number 2, 1,50,000 sanctioned for construction of slab culvert at Agri Quarter Road to Lianzoilala Road, Kanhun. And rupees 90,000 sanctioned for construction of retaining wall at Kanhun. Had not executed the 3 construction works and misappropriated all these above mentioned sanction amounts and are therefore liable for offense under section 120B, 406, 48, 468, 477A IPC read with 13.1 CD PC Act read with 13.2 PC Act.
So the FIR was lodged on 1/8/2012.
Yes, my lord.
Charge has been framed on 30/1/2015.
Yes, my lord.
After almost 3 years.
Yes.
It took so long for the investigation.
Yes, my lord.
Huh? Okay, then.
Then let me take you to the deposition, my lord, at page 10.
Who is number 1?
This is complainant number 1.
Yes.
I know the accused Samoa present in the court today. In the year 2012, I was chairman of Joint Action Committee of Kanhun Village. Sometimes during the month of July 2012, the member of MNF block at Kanhun obtained certain documents from RD block Zolnuam through RTI, wherein sanction of various development works at Kanhun under RD block work was listed. On scrutiny of such documents which were circulated, it was seen that there was discrepancies in the development works in Kanhun. According to different NGO at Kanhun gathered together to discuss the matter and decided to constitute JSC to look into the matter. The JSC decided to organize protest march. Thereafter, JSC member visited the spot where the development works were allegedly undertaken. It was found that in some works there was actual execution, whereas in some other works there was no execution. Since JSC did not have expertise to look into the matter, the same was referred to SCB for due investigation, along with document received from through RTI. Thereafter, I and Secretary Takima JSC submitted FIR on 1/8/2012. Exhibit is the FIR submitted by me. Exhibit 1A is my signature. Exhibit 2 is the copy of document received through RTI. Cross-examination. The accused was President Village Council of Kanhun Village during the term 2009-2012. He was elected from the Congress Party. All the other members of the village council during the above-mentioned term were from Congress Party. I was not member of the village council. I was a primary member of Congress Party at Kanhun. I also contested as independent candidate to the village council in the year 2012. The accused was elected as a member of village council Kanhun through Congress Party in the year 2000. I think it was 2012. The total amount in the document enclosed with my FIR was rupees 38,73,238 as per documents circulated by the MNF party, which was obtained from RTI. My lord, in the church head, it was, the total amount was 4,66,395. The exact amount of discrepancy from the sanctioned amount was not determined, verified by us. The matter was referred to SEB for further investigation. I was never a member of the village council. I was nominated as chairman of JSC Kanhun village. The supervisory agency is the RD block zone 1. My lord, may I skip 2 paragraphs?
Yes.
I had learned from hearsay that some funds were diverted. I have also learned that some funds were diverted for road leading to Baptist Church, Kanhun. The amount was rupees 2,26,395 and rupees 1,50,000 and rupees 1,64,520 and rupees 90,000 were allegedly diverted. So he also stated that it was diverted and the road has been constructed. Works within the village for the interest of the community as per the statement made before SEB. The other sanctioned amount were also utilized as per work mentioned against the money drawn. If there are discrepancies in utilization of the development works, it is beyond our knowledge. The work executed were usually supervised and verified by RD Block Zone 1, and we do not have anything to say in the matter. The FIR does not specify alleged any particular work discrepancies. The same was referred to SEB for further investigation. So, my lord, he clearly stated that some sanctioned amount has been diverted and it has been utilized for construction of works.
There were 2 enclosures in the FIR. 2 enclosures. Response to RTI, then select list of areas.
Yes.
These are exhibited or not?
Exhibit 1 is the FIR submitted by me and the Secretary JSC. Exhibit P1A is my signature. Exhibit P2 is the copy of document received through RTI. That's all.
Where is the enclosure to the FIR? These are not exhibited
In the
by the prosecution.
Yes. In the deposition, it seems that they have been exhibited.
Where?
FIR and...
No, FIR is there, but
yes.
along with the FIR, there are 2 documents enclosed. Where are they?
I don't know, my lord. I could not find it.
No, it's not. Is it not exhibited before the trial court?
I don't think so, my lord. Because, my lord, the RTI copy also, I could not find it. And the RTI copy could not be deposed could not be found by the IO himself in his deposition.
RTI copy could not be found.
Yes, by the IO himself.
Okay. So let us see the charge sheet. How did they file the charge sheet?
The charge is at page 2, my lord. That's all.
No, charge sheet. The ACB has not filed charge sheet.
SCB, they have their own style of investigation, my lord.
Maybe,
Just like
but-
CBI.
No, but without, even if it be CIBI or whoever, FBI or whatever, they have to file a charge sheet.
Yes, my lord.
That these are things under which the person is found
And-
to be prima facie
Yes.
guilty and
Yes.
is established. So they send it to
And-
the court.
The seizure form also, my lord. They have seized so many documents and the seizure form is not, I could not find it.
Charge sheet is here in the case record 73.
In my paper book, it is not included, my lord.
It's not available in my copy also. I'm talking about the case record. But where is page 73? Okay, this is the one. Final report. Have you enclosed in your appeal? This is a jail appeal or you have filed from outside?
I filed by myself, my lord.
Okay. You have not enclosed the charge sheet also?
No, I only got the impugn order, my lord.
Charge sheet runs in 9 pages. How come it's not available in the paper book? Mr. Aldrin, it is available in the paper book.
Oh,
Starting from page 125, no, 124, no, 123. 123 to 134. This is the charge sheet. So back to that question. You say that RTI, the inquiry officer, investigating officer, in his deposition say that he has not seen the RTI.
yes, my lord.
How can that be? It was enclosed to the FIR. That was the very basis of the investigation. Yes, please continue. Mr. Aldrin, you want
Yes.
some more time?
No, my lord.
Then?
And may I take you to page 12, my lord?
Yes. PW2.
This is the PW number 2.
Who is he?
And he's the brother of PW number 4. PW number 4 was recently removed from the Congress party. And he joined the MLF. So this is PW number 2, who also submitted FIR.
Who's the signatory of the FIR also?
Both of them, PW number 1 and PW number 2. I know the accused person who is present in the court today. I am a carpenter by profession. At the relevant time, I am the vice president, YMA Kanmun branch. The money for development of Kanmun village, sanctioned by the government of Mizoram through RD Block Zone, was asked to RTI by MNF party. From the document we get by RTI, we came to know that there are development funds not utilized for public purposes by the Kanmun Village Council. From the RTI, we found that in 3 places, location, we find that the development work was not done at all. Number 1, 2,26,395 for construction of culvert in between Guboi to Markai, WRC Road. 1,50,000 for construction culvert between agriculture to Lian Zoilala Road. Number 3, 1,64,524 construction of slab culvert in between Goboi to Markai, WRC Road. As we have submitted FIR against the VCP Kanmun, present accused to SCB Aizol. Before submitting FIR, we went to the spot and we found no development works done in the 3 mentioned places above. After the FIR submitted FIR to the SCB Aizol, SCB staff came to Kanmun village and I was examined and my statement was also recorded. Exhibit P1 is the FIR submitted jointly by me and C. Vanal Peka. Exhibit P1B is my signature. Cross-examination.
Just a minute. As per the FIR, no, as per the charge framed,
Yes,
there are 3 amounts which have been put forth
yes, my lord.
on the charge: 2,26,000, 1,50,000, and 90,000. Out here, that 90,000 is not there, and 1,64,000 is there instead.
This 1,64,520, that has been deducted by the BDO, and they have sanctioned only 90,000.
Okay, please carry on.
During 2009-2012, accused was the president of village council, Kanmun. At the relevant time, I was holding the post of group assistant secretary in the Congress party and the secretary of Joint Action Committee, Kanmun village. It is a fact that we did not mention the amount which I have mentioned in the examination in chief, in the FIR, Exhibit P1. It is a fact that I personally did not know the funds earmarked for development works are paid by the zone on BDO. I personally did not know as to whether the accused received a sum of rupees 2,26,395 for construction of culvert in between Goboi to Markai, WRC Road, rupees 1,50,000 for construction of slab culvert between agriculture to Lianzal Lianzoilala Road, rupees 1,50,000 for construction slab culvert in between Goboi, Markai, WRC Road or not. I personally did not know as to the queries made by the MNF party when the RTI application was submitted. I also did not know whether MNF party questioned as to whether the said amount, rupees 2,26,395, 1,50,000 and 1,50,000 were utilized any other public purpose or not. When the funds are released to the concerned village council, I do not know as to who used to supervise the works. Even in the year 2012, the accused was re-elected as president, village council Kanmun, for a period of 3 years. This year, P. So-and-so of MNF party was elected as VCP Kanmun. I personally saw the receipt issued by VCP from SCB authorities to all the works mentioned along with my FIR, except one work for which receipt was issued by one R. Lianbonga, village council secretary, but I cannot say which work it was. It is a fact that the controlling officer for works executed by the village council was BDO Zone 1. It is a fact that the village council has to function as per the instruction of the BDO. I personally did not know regarding the diversion of above-mentioned funds for other development works within Kanmun village as per the instruction of the BDO Zone 1. I do not know whether the accused had utilized the fund received for development works mentioned above as per the instruction of BDO Zone 1 or not. It is a fact that I personally did not know anything about misuse of funds for development of works allotted to village council, therefore requested the ACB to investigate. It is a fact that the FIR did not mention anything about specific works for which funds were allotted. It is a fact that if the officer in charge of the RD Block Zone 1 is satisfied regarding the expenditure of the funds handed over to VCP, we have nothing to say.
Yes.
So, my lord, the complainant number 2 also did not know, and he is not sure whether the
Both 1 and 2, they say that we filed FIR because we came
Yes.
to learn that the development works
Yes.
had not been executed.
Yes.
And after asking for RTI, we found that there was some irregularity. We did not find the work to have been executed, so we filed an FIR requesting the ACB to investigate the matter.
Exactly,
So
my lord.
that much only they
That
know.
much only.
Then number 3 is the IO.
No. Oh, he is a preliminary inquiry officer, my lord.
Yes.
I am presently posted as inspector in the SCB police station at Aizawl. Complaint dated 1/8/2012 was submitted jointly to SPSCB by C. Vanal Peka, Chairman, Joint Action Committee, Kanmun, and PC Lal Takima, Secretary, Joint Action Committee, Kanmun, stating that sanction amount for development of Kanmun village during the year 2009-2010 has not been utilized for the purpose. The SPSCB registered preliminary inquiry number 19 of 2012 was registered on 6/8/2012, and the case was endorsed to me for inquiry. During the inquiry, I collected sanction order in respect of development of Kanmun village from the office of BDO Zone 1 relating to NREGS, material components and other documents. The collected documents revealed that sum of rupees 32,52,395 under MG NREGS, material component for development of Kanmun village was released. Out of the said amount, rupees 31,2,395 was released in the name of VC Kanmun, while the rest was released to private person. The release amount is the disposal of the VCP, the accused. The reason for release of funds to private person was to help him for medical treatment. Out of the release amount, of rupees 31, 2095, rupees 26 lakh 36 was found to have been utilized as per sanction. The balance amount of rupees 4 lakhs 66,395 is reportedly diverted from original worksite and was utilized by the accused, who was the VCP Kanmun. Rupees 2 lakh 66,395 was sanctioned for construction of slab culvert at Takebul Road, Goboi, Markai, WRC Road, and rupees 1,50,000 was sanctioned for construction of slab culvert at Agriculture Quarter Road, and rupees 90,000 was sanctioned for construction of retaining wall. The said sanction amount of 4,66,395, which is said to have been diverted for other works within the village, is found not to be executed. The works alleged to have been done were found to have been executed from the wages component contributed by the job card holders. I have examined witness to verify that rupees 4,66,395 was not utilized by the accused for the purpose and was utilized by the accused himself. Therefore, submitted my inquiry report. I therefore submitted the FIR against the accused as per decision of the government of Mizoram. Exhibit P8 is the FIR submitted by me. Exhibit P8A is my signature.
Can we just have a look for a moment, Exhibit P8? Where is it? Page 122, I think.
122. May I read, my lord?
Yes.
I have the honor to state that written complaint against Village Council Kanmun was received from C. Vanalpeka, Chairman, and P.C. Lal Takima, Secretary, Joint Action Committee, Kanmun, alleging misappropriation of development fund for Kanmun Village under Zone RD block during 2009-2012. Hence, SEB inquiry number so-and-so dated 6/8/2012 was registered and inquired into the matter. The matter was taken up by me and inquiry report was submitted. On the strength of my inquiry report, Director SCB instructed to register criminal case against Pusa Moya VCP Kanmun Village, since the complaint was received from public interest. During inquiry, it is ascertained that the sum of rupees 32,53,395 under NREC material components for development of Kanmun Village was released. Out of 32,52,395, rupees 31,02,395 was released in the name of Village Council Kanmun and fully received. Further, the inquiry revealed that out of 31,02,095 received by Village Council Kanmun, rupees 26,36,000 was utilized for the purpose it was sanctioned. The rest amount, 4,66,395, which are reportedly diverted from the original work site under material components utilized by the Village Council, are actually done under wages component distributed by the public. Hence, an amount of 4,66,395 was misappropriated by Pusa Moy VC Kanmun. I therefore request you to kindly register a criminal case under appropriate section of law against so-and-so of Kanmun, Marveng, for misappropriation of rupees 4,66,395, sanctioned for development of Kanmun Village under indirect material components.
So preliminary report was made, then he was instructed to file FIR,
Yes,
and so this is the FIR.
yes.
It was registered, then
may I take you to cross-examination, my lord?
Yes, just a minute now. Just a minute.
He had submitted inquiry report and he had submitted FIR. And the inquiry report is not included in the charge sheet.
So, page 1 is the FIR, you said, but this is only a complaint.
Yes, complaint.
Case was not registered,
Yes,
isn't it?
yes. Preliminary inquiry has, they have done the preliminary inquiry.
ACB inquiry number so and so
Yes,
was registered. Inquiry was registered for preliminary inquiry. Then, after that preliminary inquiry, he files the FIR. Then, ACBPS case is registered. Yes.
page 15, my lord,
15.
1-5.
Yes.
It is a fact that I do not found the inquiry report submitted by me in the case record. The sum of rupees 31 lakh 2,395 was received by the VCP Kanun during.
Just a minute. What is the inquiry report submitted by him?
Based on the inquiry report, he has submitted FIR.
So where is that inquiry report?
He could not find it, my lord. The inquiry
the
report itself is not included in the charge sheet, my lord.
Let us go back to the charge sheet again. Let's see. All right. Please go ahead.
I did not inquire into the mode in which the information was collected by the complainant. It is a fact that I cannot give information to the court as to who were examined by me during my inquiry. And I have also not mentioned in the FIR those people examined by me from whose statement I have come to the findings in my inquiry. It is a fact that I did not examine BDO who were holding the post of BDO Zolnom during the period 2009 to 2012. I know that work order and the money were paid to VCP Kanun by BDO office at Zolnom. I do not know who is to inspect the work executed by the VCP Kanun. I do not remember the period which the accused was VCP Kanun. However, he was the VCP of Kanun when the said money was sanctioned and also during my inquiry. It is a fact that I cannot produce any document showing that the accused received the sum of rupees 31 lakh 2,395. It is a fact that during my inquiry, I came to learn that the works under RD block was to be executed by VCP under the supervision of the officers of the concerned RD. I do not know as to the party inclination of C. Vanal Peka and PC Lal Takima. The accused, however, was elected from the Congress party. It is not a fact that a sum of rupees 4,66,095 for the interest of community. It is not a fact that the sum of rupees 4,66,395 for the interest of community within the village.
So I think they meant to say that
Yes.
it was spent for the community.
Yes.
Some words are missing.
Yes, my lord. It is a fact that I did not examine anybody from the BDO office who actually verified and supervised the work executed by the VCP. So, my lord, this very crucial cross-examination by the preliminary, he has done the preliminary inquiry without examining the person from where the money was received by the VCP. That is the BDO office. I have no opinion regarding the statement of the BDO and staff of the BDO office that the VCP had executed all the works to their satisfaction. It is not a fact that the VCP executed the work with the amount he received and not from the wages component contributed by the job card holders. I do not know the reason why my inquiry report was not submitted along with the charge sheet by the IO. It is not a fact that the entire amount of rupees 4,66,395 was utilized for the purpose it was sanctioned, and there was no misappropriation. So, my lord, it's all denial.
So I do not know the reason why my inquiry report was not submitted along with the charge sheet by the IO.
Yes, my lord.
Now, if you go to his FIR, he has not enclosed anything.
It's not enclosed, my lord.
There's nothing enclosed, so how will the IO enclose it? Yes, then?
PW number 4.
Who is he?
He's a Caesar witness. There were 8 Caesar witnesses, my lord.
Seizure of what?
From the house of Mr. Sabmoya. Saving bank.
Okay, from his house.
Yes.
From the accused?
Yes.
Appellant?
Yes. From the accused and his relatives.
Okay. Why was he keeping so much accounts? Bank account books? This is PW4, isn't it?
Yes, PW4. PW4 is the brother of PW number 2.
Please read on, I know the accused person.
I know the accused person who is present in the court today. I am a businessman by profession. In the year 2009-2012, I am member of Village Council Kanmun along with the accused, Pusap Moya. At the time, I am holding treasures of Village Council. On 2012, the SEB seized some documents from the house of accused, Pusap Moya, and I am one of the Caesar witness. Exhibit P23 and exhibit M12, M9, and all belongs to different name.
It was seized from whom?
From the house of Pusap Moya.
Okay.
Though I am a VC treasurer at the time, I am ignorant about the said sanction of development funds as mentioned in the FIR. I was not informed by the VCP present accused at the time. The money that came into my hands as VC treasurer is only meant for the 100 days wages to be used by the people. All other sanctions for development funds from the government were kept by the VCP at the time. The development fund sanctioned by the government of Mizoram for Kanmun village, as mentioned in the FIR, is not known to me till it was given in the statement of RTI. As far as I remember, the money for 100 days wages kept by me was utilized by working development works within the village. As long as I remember, the following development works were done within Kanmun village by the money kept by me as follows. There are 10 items. What I wanted to say is not development fund issued by the government of Mizoram for Kanmun village. Kanmun village development mentioned in the FIR is not diverted for other development work within Kanmun village. As I mentioned above the developmental work within Kanmun village is funded from the 100 days wages, money kept by me as a treasurer. All the works I have mentioned are monitored by the monitoring committee, and it can be ascertained and proved from the monitoring committee. Cross. PCL Takima is my brother. Bank account is opened in the name of Village Council Kanmun in the Mizoram Rural Bank. It is not a fact that the bank account book and checkbook belonging to Village Council are kept by me. It is a fact that from 2009 till 2012, I was treasurer of Village Council Kanmun. I was elected member of the Village Council during the period. It is not a fact that the fund earmarked for construction of VC house was handed over to me as I had misappropriated some money. It was taken over by Vice President of Village Council. Whenever the funds was released for any development work, it was monitored by the officer of Zolnuam, BDO. Whenever fund is released from the BDO office for development works, there are two kinds of components. One is wages component and the other is material component. It is not a fact that the development works mentioned above in serial number 1, 2, and 10 were from material components and 4 to 9 from wages component. It is not a fact that I was removed from the Congress party due to manipulation of funds earmarked for development. It is a fact that all funds received by Village Council of Kanmun are routed through BDO Zolnuam office. After I was removed from the Congress party, I joined the MNF party. It is a fact that I have not mentioned anything about not using fund earmarked for certain developmental work in my examination in chief. I cannot say before the courts as to how much money was received under wages component by me. From the wages component, the amounts kept with the Village Council were utilized after it was decided by the monitoring committee. Monitoring committee is informed at the supervision of BDO Zone 1 or staff of BDO. It is a fact that since funds are routed through BDO Zone 1, they used to direct the Village Council to take up works on priority basis, even though the fund earmarked for specific work. My Lord, this is very important, my Lord.
Which one?
It is a fact that since the funds were routed through BDO Zone 1, they used to direct the Village Council to take up work on priority basis, even though funds are earmarked for specific work. So, my Lord, others are not necessary, they are only a denial. My Lord, page 20. He is also a Caesar witness of the previous deposition, the PW number 4.
Yes.
I know the accused who is present in the court today. On 2012, Inspector R.H. Lardin Lua and his staff came to Kanmun village in order to search the house of the accused. As per the secret warrant was issued. I and PC Lardin Moya, VCM Kanmun, are requested to witness the search and to become a Caesar witness. SCB staff prepared search. By seizing various bank accounts opened in the name of the accused and his others family member. The SCB staff also prepared Caesar memo, and I became one of the Caesar witness in the said search and Caesar memo. Exhibit P3 and P4 and Exhibit M1 to M9. They are in the different name. In the year 2009-2010, I was a member of village level monitoring team presenting the Presbyterian Church, Kanmun. The main objective of the village level monitoring team is to make work proposal with the VC members from the fund received under NREX and to supervise the work. During this period, I was entrusted to supervise the construction of approach road, slab culvert at Vang Lui by utilizing money contributed by the people out of wages component. As far as I know, there is no other fund received from the government for the construction of slab culvert. First, during the relevant time, 2009 to 2012, PC Moy was treasurer in the village council, Kanmun. I was never elected as village council at any point of time. As far as I know, treasurer's job is to receive and disburse. I was doing the job entrusted to me by the president, village council. I do not remember the names of persons in the VLMT at that relevant time. The development funds earmarked for the development of our village had two components, namely wages components and material components. Wages components was maintained by the treasurer and also distributed by the treasurer. I do not know what is meant by material component. When I was constructing the approach road to Vang Lui, I used to receive money from the treasurer. I do not know who used to supervise the work executed by me. I do not know, it is not a fact that the money is for construction of culvert to Vang Lui Road was from material component and not from the wage component. I did not know the amount received by the village council Kanmun towards wage component. Treasurer, namely PC Lalramoy, used to disburse the wages every evening after the work for the day was completed. I did not remember how much money was received by me as wages for doing the construction of culvert Vang Lui Road, as the work was done long time back. The monitoring committee is informed by the order of the BDO Zone 1. Monitoring committee is formed by the order of BDO Zone 1. Though I was in the monitoring committee, I did not supervise work done by monitoring committee except the one I mentioned above. During the relevant time, I was Unit 3 Vice President of the Congress Party. The accused was also in Congress Party. At the time, PC Lalramoy was also in the Congress Party. I know PC Lalramoy was removed from the Congress Party and he joined the MNF. It is a fact that wages component was prepared by Zone 1 BDO. I also do not know how much money was received by the treasurer of the village council, earmarked for wages component. I know that Ram Mingi, wife of accused, used to do business by selling. Oh. Now the BDO, the position of BDO, my lord, at page 22.
Yes.
I know the accused person who is present in the court today. In the month of January 2010, I was transferred and posted as BDO Zone 1, RD Block, Mohammed District, Mizoram, and working there till 31/3/2011. Now I am working as Under Secretary in the Department of RDI Zone. While I was working as BDO Zone 1, RD Block, a sanction was accorded for Kanmun village amounting to rupees 1,64,520. However, the actual verification of the work is felt that the work required by Kanmun village has to be re-sanctioned or other work. This is as per the planning process prescribed by NREGA operation guidelines. So they can divert some amount of money for some other purpose. Hence, the resanction amount to rupees 90,000. This is due to the actual verification of the field, verification made by the engineers of the block officer for the works to be taken up. The balance amount of rupees 74,520 was diverted to the other villages for more durable works. The office maintains the actual pay receipt APR and payment register for all the works under NREC, and this was fully disbursed to all the village council as per the sanction accorded for the said block. I was cross-examination. I was the BDO Zone on block since 2010 to 31st March 2011. The sanction of rupees 1,64,520 for the construction of WRC road slab culvert done by DRDA Mohammed District without actual verification. The reason why such sanction was made was due to the lack of time within which the project should have been completed, and utilization certificates should have been issued. When I was BDO, when I, as a BDO, verified the work with the help of engineer were done, I found the sanction of rupees 1,64,520 was not required. I applied for resanctioning for the work of construction of retaining wall at Kanmun, and the amount was reduced to 1,64,520 to 9,000. So, my lord, this was which they have reduced from 1,64,520 to 90,000. As per the work procedure, the total amount earmarked for development work under NREC should have been placed at the disposal of the BDO of the concerned block, from which the grassroots planning process should have been emanated. I am the chairman of the grassroots planning committee. On verifying the actual work to be executed in each village under the block, it is my duty to sanction the exact money required for taking up the actual development works, which form part of NREC scheme. During my period as BDO, the accused was the VCP of Kanmun village. It is a fact that whenever work is executed by the VC authorities, our office used to verify, and after ascertaining the work executed and obtaining photograph of the work done, I used to release the money. In the same way, the sum of rupees 90,000 was also released on obtaining all the required photograph of the work already done. It is a fact that in respect of the expenditure of rupees 90,000 released by VCP Kanmun, I know for sure the said money was utilized for the purpose for which it was sanctioned by the DRDA and released actually by our office. It is a fact that during my tenure as BDO Zone Block, I did not find any irregularities in the work executed by the accused under NREC scheme. It is a fact that I did not know the reason why the accused is facing trial in this case. It is a fact that the record maintained in my office, I do not find any loss or misappropriation of any money handed over to VCP government accused.
We'll come back in 5 minutes.
Yes.
Yes, Mr. Elder.
Re-examination. When the concerned village council within my block submitted work proposal, spot verification was done and conducted by the engineer under my office. And I used to take part to have spot verification as and when required. And as such, I could not take part in all verification as I was busy in the office to deal with other works. Regarding the construction and sanctioning of rupees 90,000 for the construction of retaining wall at Kanmun, I could not recall I had personally verified on the spot. Beside NREC scheme, we have also other development schemes such as so and so and so. Further cross-examination. It is a fact that regarding the construction and sanctioning of rupees 90,000, there is no complaint whatsoever regarding the execution of work of retaining wall at Kanmun. During the financial year 2010-2011, the waste material ratio was 60/40. That is 60% of the central allocation. Allocation will be sanctioned for wages, employment, and the remaining 40% will be set between the center and the state in the ratio of 75/25, which will be earmarked under material component. It is a fact that due to paucity of funds, the share of state government never used to be released on time. It is a fact that the wage component is directly given to employees on the basis of job card from our office. Wage component and material components cannot be mixed together and handed over separately on the basis of job card and actual work respectively. So, my lord, even the BDO himself clearly stated that there is no discrepancy or on the part of, and he did not find any misappropriation. PW number 7, he is the new BDO. Page 24, my lord.
Yes.
I know the accused person who is present in the court today. In the month of April 2011, I was transferred from Directorate of RD Aizol and posted Aizol Norm as BDO to take charge from Sui so-and-so BDO Aizol Norm. In the month of September 2014, I was transferred and again posted at the Directorate of RD Aizol as Assistant Director and working there till date. On 18/12/2012, at about 4 p.m., while I was in my office chamber of BDO Zone, Inspector R.H. Rinlu of SEB and his team came to my office and told me that they are in need to inspect and see some documents in connection with the funds released from our office to the accused, Pu Sabmoya, who then was VCP Kanmun. Then I informed Zorin Sanga, APO and Eldoma, account assistant, to collect the required documents, and my staff produced the following documents: NREC payment register, page 1 to 116, maintained by BDO Office Zone 1, with effect from 12/6/2009 to 6/8/2012. Pu Alian Bonga, Secretary VC Kanmun, in rupees 150,000, Kanmun Agriculture Road to Lalian Zoilala Road, Slap Kalvat, Siam Natur, Alak na APR Lehemi, so and so, Pu Si Samoy VCP Kanmun, in rupees 18,000 and 72,000, retaining wall Siamna, Atana Lakna, APR Lehemi, Atana Project Director, in sanction order Siam Le, Het Ihunlai BDO, Zolnom Pupol El Kuman sanction Siam, Remte, exhibit so and so. Pusa Moy VCP Kanmun in rupees 1,81,118 le 45,279 kan hunaslap kalwa chemna tana alak na le hemi tana project director in sanction order asiam ten exhibit so and so. I know that the above mentioned seized documents from our offices in connection with the fund released for Kanhun village have been executed, and the money have also been released to the concerned VCP Kanmun before I was posted at BDO Zolnuam, and it is during the tenure of Paul L. Kuma, BDO Zolnuam. As such, I have no any knowledge about the matter.
Yes.
Cross-examination. I took charge of BDO Zolnuam from Mr. So-and-so in the month of April 2011. When I took charge from Mr. So-and-so, I did not find any discrepancy on any kind of misappropriation of fund earmarked for developmental work of Kanhun. I also did not see any complaint against the accused, Samoya, regarding any misappropriation of funds given to him. All the work entrusted to Samoya under NREX was supervised by technical assistant under BDO Zolnuam. It is a fact that as far as I know, no formal complaint was received by the office of BDO Zolnuam, RD Block, regarding the works executed by the accused, the work in question. I did not personally check the documents seized from my office in order to know what were the contents of the seized article. However, my APO and account assistant had verified such seized documents on my behalf. Even APO and account assistant did not tell me that there was any irregularity in the accounts and books seized by the ACB personnel. So, my lord, even the new BDO also, he did not find any misappropriation of funds. PW9 is sees a witness and
Hmm.
9 to 15 are the seizure witness.
Seizure of what?
This is Exhibit M1 is the APR amounting to rupees 1,50,000 received by me from the cashier BDO office Zolnom on 10/9/2009. APR
Who is he? He's a secretary.
VC secretary.
Was he not examined earlier?
No,
VC secretary?
no. Treasurer.
1 and 2 is the, okay, the treasurer. This is the secretary. Okay. And PW9? PW10?
PW,
This also, no, there's no 10.
PW11,
There's no 10.
not 10. PW11 is also seizure witness.
What are these exhibits?
It's at page 105, my lord. 105. Specimen signature.
Whose specimen signature is this?
Accused.
Accused. So specimen signature was taken and he's the witness to that? Or what?
At the cross-examination, my lord, it is a fact that I did not see the accused somewhere putting his signature.
The ACB bought a letter prepared by the ACB and requested me to put my signature on as one of the witness. What is that letter? Is this the specimen signature?
Yes. From 6A to, from page 109, 105 to 109. So this witness did not see the accused putting his signature. And PW 12 is also same as PW number 11. And at the cross-examination, he stated that it is a fact that I did not see accused somewhere putting his signature in the exhibit. And at page 31 is the deposition of PW number 13, who is the branch manager of the SBI Mamit branch. At the cross-examination, my lord, this PW.
PW 13 is what?
Branch manager
Of
Mamit branch.
SBI?
Yes, my lord. And original check has been seized from the bank.
What is the amount?
Amount is not mentioned, my lord.
Let us go to exhibits 10, 11, M10. Material exhibits, where are they?
I was given only exhibit P16.
Huh?
P16. There's no exhibit M.
Is it a part of the paper book? Material exhibits, the index does not show anything.
to P16, my lord, at page 152.
No,
There's no exhibit M,
regarding material exhibits, it's not there.
not there, my lord. Page 152 is the exhibit P16.
Just open it. This material exhibits, is it referred to by the learned trial court
Yes,
in the judgment?
yes.
The judgment starts from which page?
It's 33 pages, my lord. It's 33
It starts from which page?
from page
45.
45.
You said SBI, I don't think it's SBI. Must be Rural Bank.
Rural Bank is at Zone 1, my lord. This is at Mamit.
Okay.
At page 59, para 14.
Just a minute.
He only mentioned that check number.
So what is the role of the SBI in this case?
Nothing, my lord. At the cross-examination, she stated that it is a fact that as far as I know, there is no involvement of Submoya in respect of encashment of above 3 checks. At the cross-examination, she stated that it is a fact that as far as I know, there is no involvement of Submoya in respect of encashment of above 3 checks. It is a fact that I do not know the reason why Anti-Corruption Department has seized the above mentioned check being produced by me.
What do you mean? Okay, what do you mean by PO Zolnuam? PO means project officer. Because the check is in the name of PO Zol No.1. PO,
I know BDO,
project officer.
maybe assistant project officer or something like that.
You had mentioned some other name also earlier. What was that? You said the fund comes from the, fund can be diverted by the BDO.
Yes,
DPO, you said DPO. District Program Officer, correct?
I think so, my lord. I'm not 100% sure.
So, District Project Coordinator, I think. District Project Coordinator and District Project Officer and District Program Officer, they have issued the check in favor of PO Zol Nuam. PO Zol Nuam.
It's program officer. Program officer.
Maybe program officer under the BDO.
It has not been issued to the name of VCP or like that.
No.
It has been issued in the name of PO Zol Nuam.
Yes, because they are supervise the work.
And this is the SBI check.
Yes,
And that money is deposited in the rural bank thereafter, or what?
I don't know, my lord.
Because the account books, oh, these are the account books of the individual. And they are from the rural bank. What is the name of the appellant?
Submoya.
He has got an account in the rural bank. The alleged incident happened in which year? 2012?
2012, 2009 to 2012.
Yes. PW 13 is the SBI branch manager.
Yes. PW 15 is also sees a witness of similar to PW number 13. SBI main branch. She's working in the SBI Mamit branch. At the cross-examination, my lord, she stated that it is a fact that I do not know the reason why SCB personnel seized exhibit M10 and M12. From the checks, I could assume that checks M10 and M12 were encashed by BDO Zolnoam, and exhibit M11 was encashed by Zedlal Biak Luanga. So this exhibit did not contain any things from which prove that the accused has encashed this amount of money.
Who is Lal Biak Luanga? Zedlal Biak Luanga?
I don't know, my lord. Definitely not the present appellant.
So PW 15 is also the branch manager.
No, she's working in the as assistant
Okay.
under SBI.
Assistant.
PW number 16 is the UDC at BDO office.
Yes.
May I read, my lord?
Yes.
I know the accused person present in the court today. In the year 1974, I was appointed LDC in the office of BDO Zone 1. In the year 1988, I was promoted to the post of UDC and transferred to DC office Aizol. I was transferred and posted at different places. In the year 2011, I was again promoted to the post of assistant and transferred to the office of Directorate RD Department Aizol and working there till I retired from service on superannuation from so and so. After retirement, I again settled at Zone 1 village with my family. On 18/12/2012, sometimes in the afternoon, while I was working in the BDO office Zone 1, some SEB staff came to BDO office Zone 1. They see some documents in connection with the development works and funds executed by the VCP Kanmun from Pulal Nundika, BDO Zone 1. This is the new BDO, Nundika, BDO Zone 1. I was requested to witness the seizure. I put my signature in the seizure memo and in the list of seized document as one of the seizure witness. Exhibit P7 is the property search and seizure memo. 7A is my signature. 7A is list of seized document. 7A is my signature. Exhibit M13 to 16 are the seized document. Cross-examination. It is a fact that BDO office never made a complaint against the accused regarding any kind of misuse of funds for the purpose of development works under VCP Kanmun. It is a fact that according to my personal knowledge, Pu Samoy never used the money sanctioned for any specific project for himself. It is a fact that I did not go through the contents of seized article exhibit M1 to 5. It is a fact that as far as I know, there was no discrepancy, irregularities in respect of funds allotted for preparing slab culvert retaining wall. As far as I know, there was no irregularities in respect of APR. I do not know the reason why accused Samoy is facing trial in this case. So those persons working in the BDO did not know any misappropriation.
Okay, that is PW 16. She was working as what? No, he. He was appointed as LDC, then thereafter promoted to UDC,
UDC and then
to assistant.
assistant.
When was he there in the Zone 1 BDO office?
On 18/12/2012, sometimes in the afternoon while I was working in the BDO office, Zone 1, he said that.
He said he was promoted to UDC and transferred to DC office ISO. So after he was...
And again promoted to assistant and transferred to the office of directorate.
So at what point of time was he working there, yes, in the BDO's office? He says that on 18/12/2012.
2014 he was assistant, and on 18/2012 he was working in the BDO office. Maybe he is the program officer or some.
No, I don't know. We can't presume. We can't presume also. So anyway, next person is PW 17. How many witnesses are there in all?
Altogether 16.
Huh?
Altogether 16 witnesses.
16?
Yes. 16.
No, I think it's more than that. If you go through the paper book, I've seen 19 prosecution witnesses.
Oh, 19. DW 1.
Yes, who are they? 17. Who's 17?
He is also a seizure witness of Exhibit M13 to M16. APR amounting to rupees 18,000 and 72,000. M14 is actual APR amounting to rupees 1,50,000 paid to Alalyan Tuanga, Secretary Village Council Kanmun. Exhibit M15 are APR amounting to 18,000 and 72,000 paid to accused Sab Moya for construction of retaining walls. Exhibit M16 is the APR amounting to 181,116 paid to accused Sab Moya for constructing slab culvert at Kanmun. And this witness, in his cross-examination, he stated that I do not know any irregularity in connection with Exhibit M13 to 16. Exhibit PW19 is the PW18 is the forensic expert.
What was sent for forensic examination? Signature?
Signature.
Specimen signature.
Specimen signature of the accused.
So he has not said anything. What has happened?
And cross-examination is also declined, my lord.
It is declined because the specimen signature had tallied with the signature. It was compared with which document?
I don't know, my lord. And PW19 is the person who submitted charge sheet.
What is the requisition? Where is the requisition for that specimen for FSL examination? It must be there. Otherwise, why should they just take it for fun? 25th of April 2013, something was sent. And what is that? Where is the forwarding letter? Page 114 is the report. Person who wrote the specimen signature, further marked here as S1 to S50, also wrote the question signatures, further marked as Q1 to Q8. Q1 to Q8, Q1 and Q8. What is Q1 and Q8? APR.
My lord, if I may, why not the, as per the records that I can see, in page 104 is the specimen seal used in the package of exhibits, which is forwarded to the joint director, but I believe that this is incomplete because it ends with to the joint director of forensic science laboratory ISO, and the next page is the specimen signature. But this was referred by the learned trial court in page number 61, para 18, exhibit P6. The learned trial court have stated that he deposed that requisition letter dated 12/11/2012, exhibit B6, was received from the additional SP-SCB along with the questioned documents. The questioned documents, I believe, is in page number, it starts from page number 110 of the paper book.
APR.
Yes, the APR. The check, the APR, sorry. The APR and the specimen signature was sent for comparison. But then I believe that the requisition letter is incomplete in this paper book, my lord. Because
What is the date of the requisition letter?
12/11/2012. Sent by the additional SP-SCB.
Signature is 25/4/2013. Isn't it?
Yes. So But it was packed and sealed in the presence on 25/4/2013. So I'm a little bit confused. Requisition letter 12/11/2012, which we cannot find in the paperwork. But specimen was packed in 2013.
No, you come to page 115. This is the report given, isn't it?
Yes.
The first line says, kindly refer to your memo number so-and-so dated 25/4.
2013, yes.
So this is the same date, the date tallies. If you come back to
Okay.
104,
I see. Maybe it's a.
the date is 25/4/13. So this is the
Correct, yes.
forwarding. So anyway, the cross-examinations declined because the specimen signature and the question signature, it tallies. What is there to cross-examine?
Yes.
I was a little surprised with the deposition, that's all. She should have said, oh, he, I don't know whether it was a female, he should have said that in terms of the requisition given on so-and-so, we examined the signatures under all the scientific, what you call instruments and all that, and we found the compared signatures and the question documents to be similar. And exhibit so-and-so is my report.
Yes.
That much. He's simply saying, this is my report, that is my report, and what is the report, we
Yes.
don't know. So we have to dig on the report and see what has happened. Anyway, PW 18 is over.
PW 19.
19,
IO, who submitted charge sheet.
yes. I think this is important,
Yes,
but we'll have to come back at 2.
yes, my lord. The
Starting
judgment
to-
itself is 30 pages, my lord.
Judgment is 30 pages.
Yes, more than 30 pages. But it reproduces a statement of a deposition of all the witnesses.
You can put back this thing in the cover, okay? Envelope shouldn't get misplaced otherwise. We'll come back at 2. Are you relying upon any authority?
No, my lord. Only on evidence. All the prosecution witness deposed in my favor, my lord.
And what about Miss Mary? Any
No, my
authority?
lord, I will not rely.
Okay. Yes.
page 37, PW 19. I am presently posted as inspector in the ACB police station, Aizawl. I am the investigating officer of the present case. Complaint dated 1/8/2012 was submitted jointly to SPSCB by Vanal Peka, Chairman, Joint Action Committee, Kanmun, and PC Lal Thakima, Secretary, Joint Action Committee, Kanmun, stating that sanction amount of development of Kanmun village during the year 2009 to 2012 has not been utilized for the purpose. The SPSCB registered preliminary inquiry number 19 of 2012 on 6/8/2012. The case was endorsed to F. Nkunga for preliminary inquiry. He found that rupees 4,66,395 was misappropriated by the accused, Pu F. Sadmoy, who is present in the court today. He therefore submitted an FIR against the accused. At this stage, the witness prayed that he requires some time to refresh his memory. His prayer is considered and allowed. And the next page is the continuation. As per the inquiry report, rupees 4,66,935 was misappropriated by the accused. Breakup of the said amount is from withdrawal of rupees 1,81,116, white APR dated 3/3/2011 M16, and rupees 45,279, APR dated 3/3/2011 Exhibit M17, and rupees 18,000 white APR dated 8/7/2011 Exhibit M15, and rupees 7,200 APR dated 28/7/2010 Exhibit M15 by the accused himself. The rupees 1,50,000 white APR dated 10/9/2009 Exhibit M14 was drawn by Alalian Buanga, PC Secretary Kanmun, but he handed over the entire amount of money to the accused. Out of the said amount, rupees 4,66,395, rupees 2,26,395 was sanctioned for construction of slab culvert at Goboi Markai WRC Road, that is Exhibit P11A. Rupees 1,50,000 was sanctioned for construction of slab culvert at Agriculture Quarter, 2 Lianzolola Road, that is Exhibit P13A, and rupees 90 lakh was sanctioned for retaining wall at Kanmun, Exhibit P13A and Exhibit 13B. From site verification, it is found that the said work, that is construction of slab culvert at Goboi Markai, WRC Road, construction of slab culvert at Agriculture Quarter 2 Lian Zoilala Road, and construction of retaining wall at Kanmun were not executed. It is therefore found that the said sum of rupees 4,66,395 has been misappropriated by the accused. And these are the exhibit. Cross-examination by the counsel. I had examined 17 witnesses, including 6 Caesar witnesses. The case was initiated from the complainant jointly submitted by C. Vanal Peka and PC Lon Kima. I examined 2 BDOs, Paul Lalkuma and Lal Nundika. It is a fact that the work was controlled and supervised by the Office of BDO Zone 1. It was supervised by the Office of BDO Zone 1. I do not know who is the technical assistant. I do not know how much was received by VCP Zone 1 during the period 2009-2012. Investigation into the case started from November 2012. The allegation of misappropriation of rupees 4,66,395 took place during 2009-2011. during site inspection, I was not accompanied by technical assistant. All the IAPR relevant to this case were countersigned by the BDO, who is the program officer. So, my lord, the IO was not assisted by the technical person, and all the APR, relevant APR was countersigned by the BDO office, who is the program officer.
So this is the explanation for PO.
Yes, program officer. It is a fact that sum of rupees 1,50,000 shown in Exhibit M14 was received by Mr. Lali Mbuanga, Secretary, Kanmun Village Council. It is not a fact that the BDO told me that all the works were executed by the VCP as per the sanction, and money were utilized for the purpose for which it was sanctioned. It is a fact that I did not go through the instruction rules under NREC scheme. So, my lord, this is the money was received from the NREC scheme, and he did not go through the instruction rules itself. It is not a fact that the complainant, C. Vandal Pekka, stated that the entire amount of rupees 4,66,395 was utilized by the accused within the village for the interest of the community. I did not bring the case diary with me today. I do not remember the exact amount stated in the complaint jointly submitted by C. Vanalpek and P.C. Lal Takima. Along with the complaint, certain documents were enclosed. It is a fact that I did not seize any document obtained by C. Vanalpek and P.C. Lal Takima by RTI.
So this also explains it.
Yes.
We were looking for the RTI.
Yes. It is a fact that I do not know what are the information received by C. Vanalpek and P.C. Lal Takima by RTI from the BDO office. I did not know the political party affiliation of, these are not relevant. So, my lord, may I turn to page 41. I examined the inquiry officer. He did not mention whom he examined during the inquiry. It is a fact that from the bank account statement of the accused, there was no bulky transaction. It is a fact that I did not find transaction commensurate to the amount alleged to be misappropriated. It is a fact that no checks were issued by the BDO in favor of the accused. So this clearly indicates that the signature, whatever it may be in the checks, has not be, cannot be the signature, the money has not been released to the accused. It is a fact that I did not have any document to show that the accused have misappropriated the alleged amount. It is a fact that I did not seize any utilization certificate from the BDO office regarding the work executed by the accused. This clearly states, my lord, it is a fact that I did not seize any utilization certificate from the BDO office regarding the work executed by the accused. It is not a fact that the BDO of the relevant time stated that all the monies were utilized for the proposed sanction and hand over to the VCP. It is a fact that I did not investigate the other work executed by the VCP under NREC's money received by the accused. It is not a fact that there is a material against the accused, but I filed the charge sheet falsely. And it is not a fact that I am deposing falsely. And now coming to the defense witness, my lord.
Who are they? How many witnesses?
One,
Only one.
only one.
Who is he?
He's the one working in the BDO office as additional program officer. I know the accused who is sitting in the court. I'm working as additional program officer under BDO Zone 1 since 2009 till date. The BDO Zone 1 covers 27 villages in respect of NREC scheme. The usual practice in that is that fund earmarked for a specific purpose were made by the DRD office, Mohammed. When it reached the BDO office, the purpose for which the money was sanctioned was verified by the BDO, and if he finds that if the work mentioned in the sanction letter need not be done and or the money is required for other purpose in the villages, the change is made by the BDO according to the need of the village. As far as I know, the complainant in this case made complaint on the basis of sanction of money for NREC scheme by the DRDA office at Mohammed, and the complainants never visited our office to ascertain as to whether there was any modification done by the BDO office at Zone 1. When the BDO office finds that the sanction made by the DRDA office was not proper, depending on the actual need of the village, the BDO has got authority to modify the sanction made by the DRDA so as to execute the work, which is to be given priority over the work mentioned in the sanction letter issued by the DRDA office. I know that the allegation that 4,66,395 was misappropriated by the accused is not correct, and I know that accused has utilized all the monies paid to him from the BDO office towards the work earmarked by the BDO office. I had also verified the works executed by the accused, and it was commensurate to the amount paid to him as per the re-sanction done by the BDOs. I know that for Guboye, Markai, WRC slab culvert, there was sanction of rupees 1,64,520 from DRDA office, but it was re-sanctioned by the BDO office and rupees 90,000 was paid. The re-sanction was for the purpose of construction of retaining wall. I know that 2,26,395 and 1,50,000 were utilized by the accused for more needed purpose in the village, as per the permission given by the BDO office, though the initial sanction was given by DRDA office for other purpose. During the relevant time, funds under NREC were utilized according to the need of the village, and not exactly for the purpose for which sanction was accorded by the DRDA office. Whenever we re-sanction fund for other purpose, we used to obtain verbal permission from the DRDA office. I know that the works were executed by the accused as per the supervision of the BDO office, and I do not find any reason for initiating any case against the accused in connection with the funds mentioned in the complaint. I know that if the complainant has visited our office instead of visiting the DRDA office, the complainants would not have had any material to make the complaint. Cross-examination. I do not know whether slab culvert and Goboi Markai WRC was constructed or not. I do not know whether slab culvert for Agri Quarter, Lianzalola road was constructed or not. Rupees 90,000 sanctioned for construction of retaining wall at Kalmun village was utilized for construction of retaining wall near Tripura, Mizoram bridge. I am not the official who disbursed money to the accused during the relevant period. Fund under NREC was disbursed in cash. The junior engineer technical assistant was responsible for supervision of execution of work executed under NREC. I used to accompany him during the supervision. Sanction letter used to be prepared whenever funds are to be diverted. Full allocation at serial number 21 in Exhibit 13A was resanctioned, and serial number 21 in Exhibit P13B. The accused did not receive the fund amounting to rupees 1,64,520 sanctioned at Exhibit P13A at serial number 21. Re-examination by the Learned Defense Counsel. The money sanctioned for the slab culvert at Goboi Markai WRC was re-sanctioned for construction of retaining wall, and the amount was reduced from 1,64,520 to 90,000. I saw two slab culvert constructed by the accused within Kanmun area, but I cannot say whether slab culvert was at Agriculture Quarter Lianzalola Road or not. I am engaged as program officer under BDO Zolnum on contract basis. I do not have any letter to prove due authorization by any competent authority. I told Pul Nanun Felachong to BDO Zolnum about my intention to appear before the court. He verbally permitted me to appear as witness. So, my lord, at page 45 is the impugned judgment. And it's almost reproduce the statement of witnesses and cross-examination. And, my lord, may I take you to page 66.
Yes, 66.
Para 22. The fact that the accused was a public servant is not disputed by the defense. The question to be decided is whether the accused committed criminal misconduct, more particularly whether he was entrusted with the fund. If so, whether the fund was utilized for development work. If I go to operative portion, my lord, would it be okay? With your permission, my lord. Page 68. Para
Yes.
number 28. Official working in the office of the BDO Zolnum have also deposed before the court as prosecution witness and defense witness as well. The statement made by this witness, that is PW number 6, 7, 12, and DW are required to be considered in caution. It was the office of the BDO which released money to the accused. The office was responsible for supervising and monitoring the execution of work. Any contention against performance of accused in execution of the works would be exposure of their dereliction of duties. All the said PWs had given clean chit to the accused on his utilization of funds amounting to rupees 4,66,395. This court is therefore bound to verify the situation beyond the official record of Zone 1 BDO office. Whether the fund released to the accused was actually utilized for development works is required to be examined in view of the evidence adduced by the other witness to the effect that it was never utilized as indicated in the proceeding paragraph. The project to be considered, the project to be executed by using the fund The fund in question amounting to rupees 4,66,395 were construction of step culvert at Goboi, Markai Road, Akri Quarter, Zolala Road, and number 2, construction of retaining wall at Kalmun Village. The project for retaining wall was vague from the inception as the location was not indicated in the official documents. That is, APR or sanction letters. The evidence on record revealed that 1,64,520 was sanctioned via Exhibit P13A for construction of sub-culvert at Gogboi, Markai, WRC Road. However, as stated by the PW6, the fund was diverted to construction retaining wall at Kalmun, and the project cost was slashed down to 90,000. It was, however, clear enough from the evidence that fund in respect of the other 2 projects was never diverted at any point of time. This court fails to believe the contention of the DW that the accused had utilized the fund he received for more needed purpose in the village as permitted by the BDO. There is no oral or documentary evidence to corroborate his statement. The two BDOs who appear as a witness did not mention anything regarding diversion of fund in respect of the 2 projects, though the aforesaid diversion was explained. It was clearly indicated by the other PWs that development works in other places within the village was executed from the 2 days' wages contribution of job card holders, which were well monitored by the village level monitoring team. The statement of the DW that the sanction amount of rupees 90,000 was utilized for construction of retaining wall was near Tripura, Mizoram bridge, and also did not inspire confidence in the absence of corroboration. There is not even a iota of evidence from the entire record that development work in any form was ever executed near Tripura, Mizoram bridge. Therefore, no other conclusion can be drawn except that the fund amounting to rupees 90,000 for construction of retaining wall was never utilized. The remaining question is whether project construction of slab culvert at Guboi, WRC Road, and Agri-Quarter, Lian Zoilal Road was executed by the accused. PW number 2, who hailed from the Kalmun village, categorically stated that he visited the spot and found that no work was executed. PW number 9, who was secretary of Kalmun village, had deposited the sum of rupees 1,50,000 sanctioned for construction of slab culvert at Agri-Quarter, Lian Zoilal Road was neither utilized for the purpose it was sanctioned nor any other development work. Besides PW number 3, inquiry officer, and PW 19, investigating officer, had also adduced direct evidence about what they saw during the verification of the project site. That was no work was executed by the accused. Though PW number 6, 7, and 16 have given a clean sheet to the accused about utilization of funds, nowhere do they state any material facts as regards to how, where, and when 2 slabs were constructed. They vaguely stated that there were no irregularities as regard to utilization of funds by the accused. It is therefore apparent that this witness only intended to regularize the irregularities committed by the accused, to whom they disbursed the money but who had failed to execute the work. The court does find that the accused did not execute the work for construction of slab culvert at Guboi, Markai WRC Road, and Akri Lianzol Road, or utilize the money he had drawn for the purpose of any developmental works. It is therefore clear enough that there is cogent evidence that accused did not utilize the sum of 1,50,000 and 2,26,395 he received for construction of slab culvert in the said location. So, my lord, now this PW6, PW7 and PW16, they are the prosecution witness, and the prosecution has to establish their case. And if that sanction, if they say that this sanction works has not been utilized, then let the prosecution lead them to explain what works that they have been done. But my lord, the learned trial court disbelieved the prosecution witness, and if he disbelieved, at least let them be treated as hostile witness. They are not hostile witness. In their own capacity as an officer, they have deposed before the court. And now the learned trial court disbelieved their statement, and he turned the other way around. And para 31, another vital fact which is to be taken into account is the evasive reply of the accused during his examination under 313 CRPC. What is that, my lord? Another vital fact which has to be taken into account is the evasive reply of the accused during his examination under 313. He has to put question under 313 and he has to explain any fact which had led to...
You have not read 313. So we don't know what is 313.
Yes, my lord.
How many questions were put to him?
Lengthy one.
Lengthy one?
Yes.
So according to the learned trial code, whatever questions were put to him were answered in an evasive manner.
Yes. He had answered on the basis of evidence.
Questions also based on evidence.
Yes. Some of them are not from the evidence, my lord. From his own
Which one?
opinion.
Sure, point out which one.
Question number 5. It is in the evidence that development fund sanctioned for the development of Kanhun was not deposited in the village court account maintained the Mizoram Rural Bank, Kanhun, and the village council treasurer during 2009-2012 was ignorant about fund released by the office of the BDO Zone 1, except wages component. What do you have to say?
Answer?
Answer, the amount received from the BDO Zone 1 was not much to be deposited and withdrawn. All the monies received by me from the BDO Zone 1 was utilized for the development work. The treasurer, PC Lalremoya, stated before the court that whenever the funds were released for any development work, it was monitored by the officer of the Zone 1 BDO. He further stated that the funds received by the village council of Kanmun are routed through BDO Zone 1 office. He further stated that since the funds are routed through BDO Zone 1, they used to direct the village council to take up work on priority basis, even though fund was earmarked for specific work. In this connection, I would like to state that the BDO Zone 1 office did not have any complaint regarding the monies handed over to me for executing the works. I did all works as per the direction of the BDO Zone 1 and his staff. I did not misappropriate any money earmarked for the developmental works of the village. Some occasion, the material were taken on credit and it was to be paid and there was hardly any money to be deposited in the bank. And question number 6, my lord. May I read?
Yes, if it's relevant to your case, you may read.
It is in evidence that rupees 90,000 was sanctioned by the BDO's old norm and fully distributed to you for construction of retaining wall. While you were BCP, what have you to say? In this connection, I say that the entire amount was utilized for the purpose for which it was given to me under the supervision of BDO Zone norm. Mr. So-and-so BDO Zone norm during January 2010 to 31st March 2011 clearly stated that it is a fact that whenever work is executed by the VC authorities, our office is to verify, and after ascertaining the work executed and obtaining photographs of the work done, I used to release the money. In the same way, the sum of rupees 90,000 was also released on obtaining all the required photograph of the work already done. It is a fact that in respect of the expenditure of 90,000 released to VCP Kanmun, I know for sure that the said money was utilized for the purpose for which it was sanctioned by the DRDA and released actually by our office. It is a fact that during my tenure as BDO Zone block, I did not find any irregularities in the work executed by the accused under NREC scheme. It is a fact that I do not know the reason why the accused is facing trial in this case. It is a fact that from the record maintained in my office, I did not find any loss or misappropriation of any money handed over to VCP Kanmun. From the deposition of the said video, it is evident that the said money was utilized properly for the purpose of development of village.
Such a long answer.
Very long answer. Based on the deposition of witness, my lord. My lord, may I take you to page 72, para 34 of the impugn judgment.
Yes.
In view of the facts and circumstances stated above, the accused is found to have dishonestly misappropriated the sum of rupees 4,66,395, thereby causing wrongful gain to himself, with corresponding to the laws of state of Mizoram. I therefore find him guilty of commission of offense under clause C of section 1 of section 13 of the Prevention Act, and he is convicted accordingly. He is liable to receive sentence under section 2 of section 13 of the said act. And para 37. Upon hearing the learned counsel, and in view of the submission of the learned counsel, it is found to be proper and just to award the minimum punishment awardable. He is therefore sentenced to undergo RI for a period of 1 year and to pay a fine of rupees 20,000. In case of default, to pay a fine, the convict shall undergo RI for another period of 6 months. To sum up my case, my lord, preliminary inquiry was done by one officer, and his inquiry report is not in the charge sheet, not in the case record, because in the inquiry, he has to do all the he has to examine all the witnesses and all the necessary to prove their case. But that was not in the case itself. And the copy of RTI, that is the main contention of the establishment of the case. That was also not in the case report.
Yes.
The PW1 and PW2 are the complainant, and what they have got the information was that from the DRDA office from Mamit. And if they have cross-checked it from the BDO, which the witness, all of them have said that there will be any cases filed by them. Preliminary.
What is the full form of DRDA?
District Rural Development Agency.
Okay, is it, it's a bigger office than the BDO?
BDO.
Which one is a bigger office, BDO's office or DRDA office?
DRDA.
District.
DRDA is looking after the district, whole district.
Block will be?
BDO. And the preliminary investigating officer stated that the amount released to the BDO was amounting to rupees 31,02,395. And that has not been thoroughly inquired into by the preliminary IO. Money released from the DRDA to the BDO was amounting to rupees 31,02,395. And the amount 4,66,395 has been diverted from the original work, and that has been said by the prosecution witness also, from the office of the BDO. The PW number 6, PW
How much was diverted in all? How much?
4,66,395.
Oh, that is the amount in
Yes.
question, isn't it?
Yes, yes.
It was otherwise meant for what purpose?
For making the Guboi to Lal Moi Kolal, that road, and one is agriculture quarter, WRC road.
Instead of doing the spending it on the purpose for which it was sanctioned, it was spent for what? It was spent for what reason? This amount.
As per the statement of the PW number 6, BDO, in a process prescribed by NERGA operation guidelines sanction of rupees 1,64,520 was reduced to 90,000, and the said money was utilized for the purpose for which it was sanctioned by DRDA.
What was that? Retaining wall? 90,000. total sum of 4,66,395 was said to have been diverted. Okay, BDO also has admitted it was
Yes.
diverted.
Yes.
It was diverted for which purpose? What was executed?
He said that the work required by Kanmul village is to be re-sanctioned for another work. This is per the planning process prescribed by the NREC operation guidelines. Hence, the re-sanctioning amount of rupees 90,000 is to be, this is due to the actual verification of the field verification made by the engineer of the block office.
Where
For
are you
the-
reading from?
From the deposition of PW number 6.
6.
Yes.
That's
BDO.
the BDO concern.
Yes, my lord. Page 22.
No, it speaks about that sanctioning of 164, 520.
And 90,000?
And which was modified into 90,000.
Yes.
It was reduced to 90,000. But what about the remaining amount?
The balance amount of 74,520 was diverted to another village for more durable works.
Okay, that is diversion, that was the explanation for 164, 520. What about the remaining sum? If you go by the charge, there are three amounts. One is 2,26,395. The other one is 1.5 lakhs. Third one is 90,000.
That was the prosecution witness statement, my lord.
No, that's what the prosecution has made, given the clarification, but not the entire clarification.
Yes.
It amounts only to 164, 520. He said that this much was not required, so it was revised and it was reduced to 90,000. And whatever balance remained was spent for other purpose. Okay, fine.
Yes.
But the total amount is 4,66,395. So where is the explanation for the remaining amount? The new BDO, what does he say? Because the amount, the documents which have been collected from the office, as per the deposition, if you come to page 24, serial number 1, 2, 3, 4, if you add up all these amount, it comes out to 4,66,395. So, thing is that you see, money was there, it was sanctioned for a certain purpose, and it was collected by the appellant in his capacity as VCP. It was also collected by the secretary of the village council. I think 1.5 lakhs was meant for some medical purpose. Medical purpose. Somewhere in the evidence it transpired.
So anyway, my lord, the vital witnesses are the person who are working in the BDO. And those people, they depose in my favor. All of them depose in my favor. They are the prosecution witness, not my witness. So the prosecution miserably failed to establish their case.
Who is the technical assistant under BDO Zolnom?
I don't know, my lord. If he was cited as a witness, he will be very good
You
witness.
could have cited him as a witness.
But my lord, the preliminary inquiry officer himself did not examine that technical assistant.
See, preliminary inquiry means what? It's basically to see whether there's something there or not. Instead of straight away going for investigation and filing the FIR, the ACB also is careful. Somebody can file any, like anonymous, pseudonymous complaint. Anybody can file. So, in order to find out the veracity of that allegation, prima facie whether there's any material, preliminary inquiry is done. Then once he sees that, oh, there are materials, there is something here, something wrong here, so then he asks for the FIR. Authority says, go file a FIR. Then the IO takes charge and he does all the investigation and file the inquiry report. That is how it is done. So we cannot insist saying that that preliminary inquiry report is not there, which is very crucial, because that was the very inception of the complaint. Exercise carried out to find out whether there was some material to proceed against the appellant or not. So, in the deposition of the new BDO, PW7, he says in his cross-examination, I took charge from Mr. Paul. I did not find any discrepancy. Fine. Regarding misappropriation and all that. And I also did not see any complaint against him. But one thing he says that all the works entrusted to the appellant under the MR NREGA was supervised by the technical assistant under BDO Zolnom RD block. So, technical assistant, we don't know who that was. He could have given a clear picture.
In the BDO office, they have this engineer. Some of them are junior engineers, and some of them.
So they supervise the work.
Yes.
So they should be knowing what work has been done, isn't it?
Yes. If it has not been done also, then that will be a very good witness for the prosecution.
Yes, on the other way around also, if they had produced that, and he would have, if he had deposed before the court that, no, he did not do any work,
Yes. It
then
will be very good.
it would have
case
gone
for-
against you.
Yes.
That was not done. Yes, anything else?
No, my lord. I honestly pray to allow our petition, my lord. Thank you.
See, after the FIR was filed, he was arrested. Was he on bail?
He's on bail till today.
Since when?
I think from the beginning I'm not sure.
You take the case record and just look into it and
Yes.
let me know. Meanwhile, I'll hear Miss Mary.
Please, Your Lordship, my lord,
Yes.
the present appellant is charged under three issues, three offense. Number one is rupees 2,26,395 sanction for construction of slab culverts at Goboy at Markai, WC Road. Second is rupees 15,000 sanction for the construction of slab culverts at Agri Quarter Road to Laizola Road, Kanhun, and 90,000 sanction for the construction of retaining wall at Kanhun. So, my lord, this 90,000 that is mentioned is after the diversion that is already made, as is already deposed by the PW number 6, Paul El Kuma, the then BDO. Initially, it was about 1,64,520 rupees, but then it was re-sanctioned to 90,000, and 90,000, and then the remaining amount was used for some durable other works in the village. My lord, as per the PW number 6, deposition in his cross-examination, which my learned friend have already routed through, he said that during his tenure, that is, he started joining the post from January 2010 and till 31st of March 2011. So during this time, the amount sanctioned is the charge number 3, the offense number 3 that is cited here.
What is that? 90,000?
90,000. If I may take your lordship kind attention to page number 22. The then BDO concerned, starting from the 3rd line, may I read, my lord?
Yes.
While I was working as BDO Zolnuam RD block, a sanction was accorded for Kanhun village, amounting to so and so. However, on actual verification of the work, it was felt that the work required by Kanhun village has to be re-sanctioned for another work. Hence, the re-sanctioned amount to rupees 90,000. So he talks about only the offense number 3 that is cited in the charge head. And my lord, if I may take your lordship kind
No,
attention.
that's what I pointed out also.
Yes, yes.
Because initially the amount which was sanctioned was 164,520, but on proper examination, it appeared that only rupees 90,000 was required.
Correct.
So it was nevertheless sanctioned, but the balance amount was sent.
And my lord, he have deposed in the cross-examination that it is only after obtaining all the required photographs of the work already done, he used to sanction the money. And in page number 23, he have stated that it is a fact that in respect of expenditure 90,000 released to VCP Kanghun, I know for sure that the said money was utilized for the purpose for which it was sanctioned by the DA and released actually by our office. Why I'm pointing out is that I'm going to the mentioned 3 head that is mentioned here one by one. And my lord, that takes care of the 90,000. Presuming but not admitting that that is utilized for the purpose that is sanctioned. But still there are 2 other amounts that is allegedly misappropriated. And second one is rupees 1,50,000 sanctioned for the construction of sub-culverts at Agri Quarter Road to Lysol Road, Kanhun. And my lord, in this, with respect to this, from Exhibit P12A in page number 41, your lordship will see that this was sanctioned. 141 of the paperwork.
Serial number?
21.
What is the amount?
15,000. Oh, sorry, 1,50,000.
Which column?
1, 2, 3, 4, 5, 6. The 6th column. After the column, there is a dash, the empty column, small empty column is
Before that?
Before that, yes.
My copy is not legible. How could you read it?
Mine also is not clearly legible, but I
How are you able to read it?
Because in the contents, it says constructions of trackable road, Agri Quarter Road to Lianzola Road to so-and-so. 15,000. 1,50,000. So that's...
No, that 1,50,000.
Yes.
Where is it written like that?
My lord, Serial number 21, Kanhmun. Construction of Truckable Road, Agri Quarter Road to Lianzola Road, Slup Culvert. So in the next column,
No, but this is construction of truckable road. Chart number 2 is regarding construction of slab culverts,
yes,
not truckable road.
but that is what is written, my lord. Maybe they.
But that figure is not there, huh? 1,50,000
The
is not there.
figure is there, my lord. In the first figure is 70,000. Second is 30,000, and in the next column it's 1,50,000.
How many zeros are there? 1, 2, 3,
4.
4 zeros.
Yes. So that is the total amount. The first amount is on semi-skilled and skilled wedges and on material. That is, whenever a sanction is made, it is divided into material components and wedges components in the ratio of 60/40. So the total amount that is sanctioned for the purpose is 1,50,000.
What is this document?
It starts with page number 139, my lord. This is the work order for wedge component recently sanctioned yielding necessary material component under Zone 1 NREGA block.
Work order for wage component recently sanctioned, yielding necessary material component under Zone 1.
Yes. So admittedly for this construction of work, 1,50,000 was sanctioned.
Now, if you go by the chart,
Yes.
serial number, name of village, name of work, then work code,
Work code,
then expenditure to be incurred. One is wages and skilled, one is
Yes.
semi-skilled,
Yes.
and the other one is on material.
Material.
Number 7.
7 is on material and 8 is the total amount.
7. 1, 2, 3, 4, 5, 6, 7. 2, 3, 4, 5, 6, 7.
The 8th column is the total amount.
Eighth column is the total amount.
Yes, and that is 1,50,000. I am
So-
counting from the serial number column.
Division of what? 70 and 50?
70 and 30,000.
No, I think it's 80. It cannot total to.
Sorry, 80,000.
17,000, 80,000.
Yes,
70 and 80.
70,000 and 80,000.
So, 70,000, 80,000.
Material,
70,000 is for the skill wages.
Yes.
Semi-skilled wages.
80,000 is
80
for the material
material.
components.
Okay,
Material components.
okay.
And it was that as per the APR, this was handed over to PW number 9, who was the then secretary. It is in the evidence. And then the PW number 9 have stated that as soon as he got back and received the money from the BDO, he gave the money to the accused. Shall I take your lordship?
Page
attention?
22, show me. PW 9,
PW 9,
26, page 26.
yes.
He is the VC secretary.
He was the then, yes.
Which line? As per on so and so, middle of the page.
No, significant video. On, it starts with on. On 10/9/2009, as per the instruction of RVCP Pusat Moya, I went to the office of BDO Zolnuam and I took 1,50,000 from the cashier. And on the same day, I came back to Kanhmun and handed over the amount to Pusat Moya, VCP Kanhmun. My Lord, what I would like to point out is that this on 10/9/2009, this money was taken by PW number 9 and gave the same to the appellant. And this was before the tenure of Pu LL Kuma, because PW number 6, because Pu LL Kuma have joined. My learned friend have stated that the BDO have deposed in his favor. But then it's neither here or there in my humble opinion, my lord, because Pu LL Kuma have joined as the BDO Zone 1 only from January 2010. And this 1,50,000 was sanctioned and disbursed on 10/9/2009.
By
And
the,
he was-
by
by
the previous
yes,
BDO.
by the previous
That
BDO.
previous BDO is not before the court?
Not before the court. So the evidence on record in the appellant's favor is silent on this. My learned friend have taken your lordship attention to the line or the sentence that is in his favor. But then, since all these things happened before the PW number 6 took charge, but then what is a fact on record is that for construction of this, for construction of slab culverts at Agri Quarter is not done as per the PW number 1, 2, etc.'s deposition, my lord. No work is executed. Now, I have taken your lordship attention to the work that the sanction amount 90,000 before, because 90,000 presuming but not admitting is already taken care of. But then this 1,50,000 is still, it is in the evidence that this amount of money was in the hand of the present appellant.
1.5.
1.5 lakhs. And after that, the number 3 charge, charge number 3, the nature of offense number 3.
90,000 has been explained.
90,000 is explained.
Then 1.5 has no explanation.
No explanation.
Then the other one is 2.26395.
2.26395, yes. This was earmarked for the construction of slab culvert at Goboy Markai, WRC Road at Kangmun. And the accused received the APR on dated, APR is nil, and he received the amount 2 times in parts. The first time he received 1,81,116, and second time it's 45,279. And
where is that?
this is from the judgment in order, because I do not find the material exhibit in the.
Okay, show me the judgment, which part?
Page 67, my lord. Paragraph number 25.
67.
The material exhibit I did not find, so I'm just referring to this.
67.
Page 67, para 25. I'll start from.
Is it breakup of 18,000?
Yes, my lord, do you see the, it's written in bold letter, construction of slab culvert at Goboy Markai, WC Road, in the middle of the page?
Yes.
Yes, at Kanhmun. The accused received so and so on so and so, and payment register material component on 15/3/2011 and 28/3/2011.
So when you add up this two amount, it turns out to
It
be...
comes up to 2,26,395. And then as per the deposition of PW number 7, who is the successor of PW number 6, the later BTO, he says that all this was, the work executed and sanction was done before he took charge of the office. So in PW number 6, if my learned friend is going to take a defense on that, if the benefit of PW number 6, he have, the PW number 6 only talks about the 90,000 only. And not of this 2,26,395, which he sanctioned during his tenure.
Who has exhibited this material exhibits?
My lord, I believe that from the charge sheet, I don't know why it's not included in the
Please give me that envelope again. Yes.
Yes, my lord. So what I am trying to point out is that, my lord, the PW number 1 in his deposition have clearly stated that no work was found to be executed during spot verification done by the members of the JSC. My lord, my learned friend have stated that he is trying to impress upon your lordship that this is a politically motivated case. But then the Joint Action Committee includes not only the parties, the Joint Action Committees includes the MOP, etc. And the RTI that was acquired from the government was furnished to every household, and after that scrutiny was done as per the record. And after that only the Joint Action Committee have taken the recourse of filing the FIR. Because they have found that all this work is not executed. And my lord, PW number 1 have stated clearly that no work was found to be executed during spot verifications by the members of the JSC, which is intact in the cross-examination. And PW number 2 also stated that development fund was not utilized for the purpose it was sanctioned, that is, construction of Goboy Mar WC Road and Akri Quarter Lai Zolai Road. The amount which we are referring to, my lord, 1.5 and 2.26. PW number 2 have stated that. And my lord, we see from the deposition of the then Secretary, PW number 1, that some work was done. From the records, it can be seen that some works was done within the village for development. But then in the cross-examination, they have stated that, yes, we have already pointed out there is a material components and wages components. This work was done from the 2 days contribution of wages components from the labor's wages. There is no denying that work was executed, but then it is clear from what my learned friend have already taken your lordship through, that it was executed from the 2 days contribution of the wages components, from the wages components. So what is actually used to happen in this MNREGA is that from their wages, they used to contribute sometimes, and then rather than manually plowing the fields, then they used to hire JCB, etc. to do the work. And then they themselves get the rest of the money as their wages. So that's how the system works in reality.
Otherwise, the preliminary objection, preliminary report is not there, isn't it?
Yes, it is not there.
See, from the deposition of PW3, who was the inquiry officer,
Yes.
preliminary inquiry officer, he found that total 32,52,395 is sanctioned
Yes.
for that Kanhun.
Yes.
And out of which 31,02,395 only has been released
Yes.
to the VC Kanman. And that balance is there. If you calculate the balance, it works out to 1,50,000.
Yes.
So 1,50,000, where it disappeared, it says, he says, it was released in the name of, it was released to a private person.
Yes.
The released amount is at the disposal of the VCP.
Yes.
The reason for release of fund to private person was to help him for his medical treatment.
Yes.
So then he goes on to say that in respect of the balance of 31,02,395, actual spent was 26,36,000.
Yes.
For the work, it was sanctioned. And diversion is that 4,66,395.
So, my lord, from the record and the evidence that is adduced before the learned trial court, it is clear that there is some misappropriation of funds by the present appellant, for which the findings of the learned trial court need no interference, and my humble prayer is to uphold the judgment of the learned trial court, my lord.
Mr. Aldrin, any reply?
Lordship, the charge with several heads was framed against the accused, and if the charge was framed against the accused, it is the prosecution duty to prove that that amount has been, that particular amount has been misappropriated by the accused. There is no evidence at all. There is no evidence that 2,26,395, which has been sanctioned for that particular, has been in the packets of the accused or whatever. There is no link at all. They have charged with 3 heads, my lord. 2,26,395. There is no explanation at all, my lord. And 1,50,000, that is also no explanation. And 90,000 also. Then This is the church itself, my lord. The prosecution has to establish their case with the church. They failed to establish their case, my lord. There is nowhere. All the witnesses did not say anything at all about this money. So, my lord, this is a fit case to dispose of, to dismiss the case, my lord. Thank you, Your Honor, my lord.
All right, I will have to reserve the judgment. I heard Mr. Eldrin Lomzwala, learned counsel for the appellant, and Ms. Mary L. Kianka, learned additional public prosecutor. Most of the learned counsels have made their rival submissions. Hearing concluded, judgment reserved.